Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 240 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues we provide advice and assistance to both employers and employees on all aspects of employment law. Our HR Harbour membership service is our flagship service for businesses, where for a fixed monthly fee we can provide ongoing advice and support for your business on all aspects of HR and employment law. And given the recent news about changes to the law and the changes that are going to be coming up next year, it's important that employers stay on top of all of the changes, and we can help you with that. We provide proactive support and assistance with all aspects of your HR. So if you'd like a no obligation quote, why not get in touch with me by email? It's alison@realemploymentlawsadvice.co.uk. Now, in this week's episode of the podcast, I'm going to be talking about a topic that comes up quite often when we're talking to both employers and employees about employment tribunal cases, and that is legal costs, and if you would be able to recover your costs if you're successful with your claim or defence. So without further ado, I'm going to get into this week's featured content. Now, as I say, one of the key issues that we end up talking to our clients about, both those employees who are making claims and employers who are defending them, is the costs-benefit analysis of either pursuing a claim or defending a claim. And when we're talking about this, we're thinking about things like the costs for legal defences, the cost of management time, and the general stress and time that it takes to either pursue a claim or to defend a claim. And one of the questions that we're often asked is, can I recover my legal costs if I win my case? And the answer to this is that, unfortunately, it's a bit uncertain in relation to legal costs. And on the most part, you can't recover your legal costs. Now, that's not to say that there aren't exceptions, which I'll go through. And actually, in my experience of practicing employment law for the last sort of 20 years, the frequency of the awards for costs has actually increased in my experience. So tribunals are more likely to award costs than they were maybe 20 years ago. But it still isn't the norm that the losing party pays the winner's fees. Those of you who are familiar with civil courts and civil court matters will know that quite often in a civil court case, it's the losing party who pays the costs. So costs follow the result. And so typically you can recover your costs in the civil courts, although for some of the lower level claims or small claims, those costs that you can recover are fixed. Generally, you can get something back in terms of your costs for either pursuing a claim or defending. Now, that's not the case in the Employment Tribunal. The default is that costs aren't awarded unless one of the parties makes an application for costs, and one of the exceptions apply. So one of the reasons why the tribunal will make that award. So when can costs be awarded in an employment tribunal? Well, the decision to award costs is entirely at the discretion of the Employment Tribunal, and they can make costs awards in a couple of scenarios. The first is when one party acts vexatiously, abusively, disruptively, or otherwise unreasonably in bringing or conducting the proceedings, or where a claim or defence has no reasonable prospects of success. Now, there are some other grounds on which a tribunal may order costs, but these two are the ones that are most often relied upon, and usually where costs may be awarded if the party is successful in convincing the tribunal that the other person has either acted that way or that their claim or defence has no reasonable prospects of success. Now, as I was saying, normally it's for the parties to make an application for costs, but the tribunal can also make a cost order of their own volition, although it's less likely than when a party actually makes an application. So it's quite rare in my experience for an employment tribunal to make a costs award without one of the parties asking them to do so first. Now, when the tribunal have to decide whether or not to award costs, they have to follow a two-stage test. Now, the first stage is to decide whether the conduct of the party meets that cost threshold, known as the threshold test. And this is an objective test where the tribunal decide if, based on the facts, if the conduct complained of was unreasonable and or whether the claim or defence has no reasonable prospect of success. So the first test is objective. The second stage is a subjective test where the tribunal will decide whether to exercise its discretion to award costs, having regard to all of the circumstances. So the impact of this two-stage test is that even if one of the parties' conduct is objectively vexatious or unreasonable, or the claim or defence didn't have a reasonable prospect of success, it doesn't always follow that the tribunal will order costs, because they will take into consideration whether it's reasonable in the circumstances to award those costs. So what is vexatious, abusive or disruptive conduct? Well, this refers to the behaviour of one of the parties which may be designed to harass, intimidate or cause undue difficulty for the other party. So this includes things like pursuing a completely meritless claim, one that's been pursued where the party doesn't believe that they will win, so they've only done it for the kind of hassle factor, for example, or where they've done something to harass the other party or to deliberately put them at expense. And tribunals do take a dim view of this conduct, as it completely undermines the purpose of the tribunal system, which is to resolve those fair and reasonable disputes. Now, what we quite often see is employees in particular who are upset about maybe the way they've been treated or that they've been dismissed. And even though they might have no reasonable grounds for a claim in the Employment Tribunal, they make threats to the employer that they're going to take them to the tribunal, to cause them that difficulty or to cause them that cost. And in those circumstances, that's when the tribunal would consider if that behaviour was vexatious, abusive or disruptive. Now, there was a recent tribunal case involving vexatious conduct, and this is the case of Hargreaves versus Evolve Housing and Support, and this is a case from last year. In this case, the tribunal found that the employee had pursued an unmeritorious claim in order to satisfy a vendetta that he had against his employer and to cause as much damage to them as possible. As a result, the tribunal ordered the employee to pay part of the employer's costs, which was £20,000, and the tribunal in this case concluded that his conduct was an extreme example of vexatious, scandalous and unreasonable conduct and was an abuse of the tribunal's process. Now, the reason that case has come to everybody's knowledge and has been publicised is because of the nature of the case and the value. So it is quite extreme for somebody to be awarded £20,000 in costs and for the tribunal to make that assessment of their conduct. But it's just to give you some assurance, if you're an employer or employee in this situation, that you can make an application to the tribunal for your costs if somebody is behaving badly. The other thing that we're seeing quite often in relation to the conduct of employment tribunal claims, and this goes for both employees and employers, is that they are behaving disruptively in the handling of the proceedings. So, for example, repeatedly requesting adjournments of hearings or failing to turn up to hearings or failing to follow the Employment Tribunal's directions for preparation and consistently doing so. So thereby disrupting the whole process and causing the other party to incur additional costs and additional time in dealing with the claim or defence. And so it does cover a wide range of behaviour. Now, you might be thinking to yourself, well, what exactly would constitute unreasonable conduct? Well, the tribunal will give it its normal English meaning, and it's something very similar to vexatious. So it could include actions such as creating unnecessary delays, as I say, lying to the tribunal, or, as we've seen quite often happening, is failing to comply with case management orders or directions. And when deciding whether to make a costs order for unreasonable conduct, the tribunal will take into account the nature, gravity and effect of that party's conduct. And in a recent case of Clements versus the Secretary of State for Justice from 2021, it gave a good example of unreasonable conduct. In this case, the employee had failed to progress their claim to the point that 18 months after the claim commenced, the employer still didn't have a clear picture of exactly what the legal case was that the employee was making. The employee had deliberately and repeatedly failed to comply with the tribunal orders, and they had found that this conduct was unreasonable and therefore made a significant